Hi, my name is Paul Horn. I am a California probate attorney. I'm also a CPA. I quite get the question asked from realtors, real estate professional, if a homeowner pass away, what do I do? Who are my boss? There are 4 children. Who gets to sign my listing agreement? Tax issue. Mom bought it for $100,000. Now it's worth $1 million. When the children sell the house, do they have to pay any taxes? I'm going to get into all that, okay? So let's start with who's your boss? Who's your boss? Mom passed away. Dad passed away. The first thing you ought to do to figure out who's your boss, the first thing you ought to do is pull the grand deed. You're going to pull the grand deed. When you pull the grand deed, let's say that if the house is in a trust, you don't need a probate. If you pull the grand deed and the house is in a trust, if the house is in a trust, great. You're going to want to get a copy of the trust. Get a copy of the trust, okay? When you get a copy of the trust, as you flip through the pages of the trust, you're going to come to the word successor trustee. Successor trustee. You're going to flip the pages and find that page where it says successor trustee. And right next to it, you'll see the name John Smith. You're going to see Mary Jones. That's one of the 4 children who's going to be your boss. The successor trustee is going to administer the trust. The successor trustee is your boss in signing your listing agreement. Okay, so the successor trustee, very important if the house is in a trust. How will you know if a house is in a trust? You're going to pull up the grand deed and it'll say the house is in a trust, okay? If the homeowner is Mary Smith, it'll say Mary Smith, comma, trustee of the Mary Smith Family Trust. That's how you know it's in a trust. No probate needed. You can move on, find the successor trustee, get the listing, close your escrow. Now, if you pull up the grand deed, and let's say our homeowner's name is Mary Smith. Let's say it's Mary Smith. When you see Mary Smith, when her name is on the grand deed, Mary Smith, that means not in a trust. Because it's not in a trust, you're going to need a probate. Any homeowner who passed away without a trust is going to need a probate. Okay? So now, who's your boss? Who's your boss in a probate? Who gets to sign your listing agreement? Your boss? So let's say there are 5 children, 4 or 5 children. Okay? Let's say however many children there are. One of the son or daughter who goes and petition the court to make him or herself the personal representative is known as the petitioner. So whoever comes to the probate attorney and initiate the probate process, we call him or her the petitioner. Once the judge grants the authority that him or her becomes the one in charge, then we call him or her the personal representative. Personal representative, sometimes known as PR. P, personal, or representative. Personal representative. In a probate, the personal representative is your boss, okay? And so just as vocabulary, if there's a will, we call him or her the executor. If there is no will, we call him or her the administrator, okay? So that's who your boss. That's your diagram, who's your boss, okay? Now, I'm going to talk a little bit about taxes. Quite often you're going to get asked, hey, mom bought this house for $100,000. Mom bought it only for $100,000. We're in California. 30 years later, the house is worth $1 million, right? It happens all the time. Mom bought it for a lowly $100,000. Now it's worth $1 million. Daughter says, please sell this house for us. You're our realtor, sell it. But how much tax do I need to pay? Here's the answer to that. Here's the answer to that. So, taxes. When we talk about tax, we need to address basically 2 types of taxes. We're going to talk about capital gain. Capital gain, right? You are all familiar with capital gain. You know all about capital gain. What is capital gain? When you sell a house, basically selling price minus your cost basis, right? Mom bought it for $100,000. You're going to sell it for $1 million. So in the normal world, while mom is still alive, there'll be capital gain of $900,000, right? Mom bought it for $100,000. She sold it for $1 million, capital gain of $900,000. But if she passed away, if the house is in a trust and the house is in probate, if the children receives the house after mom died, after dad died, there's a step-up basis. It's called a step-up basis, and that escapes any capital gain, okay? Mom bought it for a lowly $100,000. When mom dies, worth $1 million. As long as the children receives the house after mom died, there's a step-up basis. Step-up basis, you sell it for $1 million. Step-up basis says the children's basis is $1 million. On the date of death will be the value. On the date of death, whatever the value is becomes the children's cost basis. On the date of mom's death is worth $1 million. That $1 million becomes the children's cost basis, zero capital gain. Okay, so that's one huge issue to understand. The majority of the time, children will not pay any capital gain. Okay, now the other important issue is property tax. Is property tax. Now, mom bought it for $100,000. She lived there for 40 years. So property tax is really low. Property tax is really, really low, right? So the question is, if those children are keeping the house, does the property tax gets reassessed to $1 million? The answer is no. If mom and dad pass a house to their son, their daughter, their children, Proposition 58 keeps the house from getting reassessed property tax-wise. Okay, so make sure you have to send a daughter file this form. This form up here that you see is your Proposition 58. It's Form 58. Okay, parent to child exclusion. If it's grandma to grandparents or grandchild, it's Prop 193. It's a similar form. All right, so this form right here, very important, folks. File it. Mom and dad pass away, file it to make sure the property tax does not get reassessed. So that's tax. Just one last issue. You heard about death taxes, estate taxes. That's $11 million, 11.2. Okay, but the majority of the time, people die with less than $11.2 million. These are the two issues. I just taught you those two issues. So that's sort of tax for you. Now, I want to cover probate real fast for you. So if it's in a trust, you get a copy of the trust, you find a successor trustee, you sign your listening agreement, you go on with your escrow transaction. If it's in a probate, it's a different world. If it's in a probate normally takes 12 months to do, but a probate attorney like myself who knows how to conduct these probate in a more efficient manner, you're going to be able to sell the house in about 2.5 months. Okay, so here's what I mean by that. We start the probate process. Okay, probate takes 12 months, but you see where it says for sale right here? I would file a petition for your client, your son or daughter. 5 or 6 weeks later, I have a court hearing date. Get him or her approved. Okay. At the 2-month marks, when orders and letter comes out, I'm going to put on the screen here for you letters. Very, very important. Letters and orders. Here's letters. Letter says who is in charge. Letter says full authority or limited authority. Okay, this is letters right here. The other form, the other major form that comes up at the 2-month mark is orders. On the screen is orders. Order basically signed by the judge that says Henry, the son, Mary, the daughter, is the personal representative, okay, with full or limited authority. So letters and orders, very important. These two forms that were just on the screen for you, okay? So the majority of probate flows like this. I file a probate petition, I go to court, I get your son or daughter approved, letters and order comes out, then you now give me the accepted offer. You give me the accepted offer, okay? You give me the accepted offer. Now I put it on the notice of proposed action. This form right here is the notice of proposed action. I put it on there. I notify all the children, all the siblings that were selling the house. You know, if there is no opposition, no objection, you get to close probate. You get to close that probate real estate transaction in about 3 months if it's full authority. Okay. By the way, one more important thing: if you ever go on a listing appointment, but mom and dad pass away, someone passed away, the homeowner passed away, don't be afraid to call my office and I'll be your partner. You can put me on speakerphone and I will explain to them what is the process in this. What is the process if there's a trust? What is the process if there's no trust? I will be there at your listing appointment. Just call my office ahead of time, book an appointment, and we'll make your transaction smooth for you. Okay? Thank you for watching.